Hi, good morning, everybody.
Good morning, sir. So we'll be introducing you.
Yeah, yes, please. Can I proceed? Or
Hello.
hello.
Sorry, sir. Actually, there were some net issues. That's
No,
why.
understand. No issue. No issue.
Good morning to all, and I welcome you all for today's session. Today, we have with us our speaker, Dr. Sehgal, sir, who is a managing partner at Sehgal IPR Services. Dr. Sehgal sir has over 2.5 decades corporate experience in various functions like R&D, regulatory, marketing and IPR etc. in specialty chemicals, petrochemicals, polymers and pharma sectors. He has held responsible positions in big companies. NOCIL started Royal/Dutch Shell sponsored exploratory R&D activity for the development of potential novel agrochemicals. Sir was at Bal Pharma as a head for regulatory, IPR, and API marketing. Also at USA IPR attorney in Connecticut, USA, as a training and drafting for patents. At Honeywell as a principal scientist and analyst IPR for global IPR services. Sir was at Jubilant Organosis, head IPR for API business. Also at ARC Pharma Labs as a head for IPR responsible for all the aspects of patent related. I request Sir to please start with his session and enlighten us. Thank you.
Hi, good morning, everybody. Due to certain unforeseeable reason, this elegant who rather was to speak on copyright, he has not been able to make it. So I will try to, I do not have an expertise in copyright, but today I would like to touch upon all aspects of IP. If you look at IP, firstly, we have to look at it on what one can acquire IP. There are 4 different aspects for which an IP can be acquired. They are trademarks, design, copyright, and patents. When you talk of design, because you see every product has got a specific design. To plan a design, it does require a lot of inputs and expertise. So, for example, let me tell you, there has been case studies in the course of law, wherein packaging materials, wherein products are packed. For example, pesticides or medicines. They have specific designs, and the owner of those products have got that design registered with the Intellectual Property Right Office of India. In India, the design headquarters is at Calcutta. For example, you look at the fans, which you see moving over our head, right? They too have specific design. There have been many cases wherein the design for a specific design which has not been existing at all, but looks good or whatever it is, and they get that design registered, barring all other competitors to have that product in that particular design. Coffee mugs, glass, and likewise. Similarly, trademark, everybody knows, is a proprietary name of a product which has popular. For example, I would like to cite an example. Was it happened so in a Japanese restaurant? We wanted to have a cold drink. We were rather feeling thirsty. We asked, "Can we have a cold drink, please?" Japanese waiter could not understand and rather started saying, what? Then we said, "Can we have Coke, please?" He immediately understood. That is the proprietary name of a cold drink, which is rather known to every individual, irrespective of the language. That is the hallmark of trademark. Similarly, if we go to the patents, patents are based on technology. There are 4 aspects on which we can get patents. They are product, a new product, composition matter, like medicines, which we take in the dosage form, capsules or tablets or injection. They are composition of comprising a drug and so many other ingredients. So that is composition matter. Just to set an example. And then process for making anything. For example, drug, which we take, has to rather undergo some process for arriving at the final stage. New chemical. The main ingredient in drug is an API, active pharmaceutical ingredient, like crocin we say. That ingredient has to undergo the process for it to be made. And any company, they would rather have a lot of R&D activity to come out with an efficient and economical process. If at all they get some new process meeting all the requirement in respect of novelty and inventiveness, they get patents on those process also. Now we come on to the copyright. As regards copyright, this pertains to literary and artistic activity. Any literary work like writing novels, stories, artistic work, paintings, and likewise, including software. As you know, in India, under Section 3K, software prima facie are not patentable. However, they can be rather protected under copyright aspect of the patent IP law in India. But some software which has applicability in industry to manage machine parameters or production, those softwares are patentable in India. Because the law say 3D per se. Per se is something which has to be justified. This is something which enables machine to work in an efficient manner in a specific required manner. Then software is patentable in India. Now I will touch upon copyright a bit. Copyright is something for which there are proprietary rights for example, story writer or a novel writer. They have a lifetime protection. And after their demise also, their family members who rather inherits their rights, they also continue to have the rights. Now, copyright are also jurisdiction-wise. If earlier there used to be jurisdiction-wise, for example, if it is registered in India, it's enforceable only in India, nowhere else. However, about 4 or 5 years ago, there has been a Vienna agreement among the WTO member states. All those countries who are signatory to the Vienna agreement, then if at all a copyright protection has been sought in one country, it becomes enforceable and protected in all those countries who are signatory to Vienna agreement. There has been a new development in the copyright aspects. When we see the movies, there's a big uproar in the movies which we see on screen films. Films, anybody producer or director, they have all the rights and protection. However, as per the copyright law in India, 30 years from the date of they were first cited, they were shown on the screen, they become they are considered to become a prior art, and protection ceases after 30 years. There is a protection for 30 years. So this is pertains to copyright. Now, I will rather take it on different aspects of IP, for which there has been a TRIPS agreement. TRIPS agreement has been prepared by this WTO, World Trade Organizations, which provides guidelines for all member states who are member of World Trade Organization to enact legislation in the respective states, ensuring that IP of a one member state is rather protected by all other member states in the respective jurisdiction. As per the TRIPS agreement, under different section, under this Article 27, it says all the member states have to provide protection, have to give protection to the IP of the member state if they are submitted and protected in the respective member state, not otherwise, because patents is a jurisdiction wise, unlike copyright, which becomes enforceable and protected in all the VINA signatory countries, is not for the patents. Patent trademarks for the respective state. And Article 27 of the TRIPS agreement ensures that and makes it obligatory on the part of member state to protect it. Now, something happens. There has been a Doha Declaration and Paris Convention where it was discussed. Particularly, let's look at the pharma sector, medical sector. In medical sector, it's likely that in poor countries, the drug which is owned by a multinational company, they might have been selling in the developed countries at high price, but this may not be affordable by the masses at large in poor countries. Also, they might not be interested to sell in that country because from a business perspective, they might say it is not something which give them revenue, because every research, every new molecule, pharma molecule, undergoes lot of R&D and billions of dollars are spent. It is rather assumed out of multiple lakhs of the chemical compound tested for drug, there is a chance for only one to graduate among multiple lakhs, tens of lakhs. That is the R&D efforts required to come out with a new drug molecule. Therefore, companies who invent new molecules as a drug molecule for specific indication, they have all the rights to generate revenue, to cover the cost they have spent, and also generate profit for the future R&D. That is the case. For that reason, to ensure that such things which are health related should be accessible to all the masses on the earth, irrespective of their financial position, whether they can afford it or not. For that reason, an Article 31 is providing the TRIPS agreement, which says a member state, in Paris Convention paragraph 5, they say a member state of WTO has rights to enact legislation based on emergency. Whether it is emergency or not, it is at the discretion of the member state to define it, to issue compulsory license. Compulsory license means if at all a drug molecule is not accessible by large masses in sufficient number, supposing the requirement is X and availability is X by 2 or X by 3, that comes in quantity. At the same time, price is too high that common masses cannot afford it. On these two aspects, if drug molecule is not available, then it becomes obligatory on the part of this patent owner to give compulsory license to a local manufacturer, who in turn, without infringement, can make such a product and make it available to masses at large at affordable price and in sufficient quantity. This Article 31 is such that every member state had to enact legislation for that. In India, there is a section 85 wherein it is desirable that if at all a drug is not available in sufficient quantity, local drug manufacturer, there's a process to comply with which makes them to have a compulsory license. Initially, they have to contact the patent owner company, telling them because of this reason, it's not available. Because the section 85 also states that any patent which has been filed and granted in India has to be practiced in India. For that reason, every applicant, every company who has got a patent has to submit Form 27 to Indian Patent Office every year, indicating what quantity of product has been made which rather relates to this specific technology for which protection has been granted and revenue generated out of that. Non-submission of such a form is a non-compliance of the patent law, and opponent competitors can submit an application to the patent office for revocation of such patent. That is one condition which makes a patent suitable for compulsory licensing. Second is, product is not available in sufficient quantity. That is another reason. This is something which is at the cost of the health of the masses at large in that specific jurisdiction, is not available. And third is the price. Price is so which is not affordable for common masses to afford it. Based on these conditions, under Section 85 of Indian Patent Law, an application documents can be submitted to the patent law for compulsory licensing. To comply, to make it rather suitable, it is imperative to first contact the patent holder, telling him, amicably, let us settle among ourselves and request him for voluntary license. Voluntary license means he says, he gives an accord, he gives a permission, please use it and do it. That is voluntary licensing. Based on the agreement, terms and condition agreed upon mutually by the two parties. If a patent holder refuses, then they say, no, I want compulsory license. And for that compulsory license, it has to go to the process, and patent office has got all the rights to grant if they convince, yes, this has to be done. And it is also permitted by the TRIPS agreement under Article 31. There has been a very interesting case in India between Bayer and Cipla for one drug molecule, and the matter got escalated to Supreme Court of India. Only thing was, earlier this royalty which was agreed upon by the Indian Patent Office was 5%. When it went to IPAB, Intellectual Property Appellate Board, they increased to 7%. Then it went up to Supreme Court, which said, yes, compulsory licensing is the right decision, it is required. However, they increased the royalty by Cipla to Bayer to 10%. And likewise, there has been quite a few other case studies also in India for compulsory licensing. In that case, Bayer cannot go to or complain to any international court. Reason being, TRIPS agreement has got a provision, if at all there is a dispute, there is a rather an issue wherein a member country member country feels that their patent rights are not being protected in specific jurisdiction, they have to first complain to WIPO, World Intellectual Property Office, or World Trade Organization for Dispute Settlement Board. There is a Dispute Settlement Board. If at all there's any issue, the matter has to be escalated there. As the TRIPS agreement on record provides a provision for the compulsory licensing, and requirements for that are being met for taking such decision, so they are not going to dispute settlement board either, because they know the case is weak. So these all provisions are provided in patent law to ensure they are not misused. In US in particular, and it is rather being is not clear in other countries like India, Europe, etc., but there must be some law. Many parties, applicants, they get a patent, though they might not be using it, only to bar their competitors to be in that field. There has been quite a few case studies on that. For that reason, in US, there is a Sherman anti-competitive law. In that case, the competitor who is in that specific technology domain, they have to request for the voluntary license. If it is not issued, then they have to take up the matter to the court of law, and court decides it is violation of the Sherman anti-competitive law. Therefore, compulsory license must be issued. There has been some case studies in US for this matter, wherein one case study is very interesting, which pertains to a Xerox machine, where Eastman Kodak, they had not been giving a voluntary license to the competitor for one product which they were not using, but at the same time, they were not allowing the competitor to use that. For this matter went into Supreme Court of USA, wherein compulsory licensing was granted at 5% royalty. So there has been a lot of protection in the patent law to ensure that such protection laws are not misused by any party. Now, this is very, very important factor wherein protection is provided to both patent holder as well as the society at large. In India, in addition to provision for compulsory licensing under Section 85 of Indian Patent Law, there is another Section 92. Under 92, if the Government of India decide, Health Ministry of India decide, that this product is of great importance for the national health, for the masses at large, and there is a patent, so therefore it cannot be made in India. For that reason, Government of India, rather without informing the patent holder, in 85, patent holder has to be informed, who in turn fights with the patent office and the court of law. In 92, there is no requirement that patent holder has to be informed that we are taking it under Section 92 for compulsory licensing. Government of India decides, and then potential manufacturer has to go to the Indian Patent Office, telling them to give and permission to use this patent for the drug products. So these two sections ensures compulsory licensing for health-related products in India. Now we come to another very important aspects of patent, which is called opposition. First, I would like to touch upon the patent term process. There is a law that protection is given against disclosure of the inventions to the society. For that reason, there is a provision in India, in all countries, to file a provisional application. When you think that you have got an idea, you want to protect it, at the same time you're scared. Somebody else might also be working, so I must do it fast, but I still have to do something in that, some work is left. For that, there's a provision to file a provisional application. In provisional application, you don't have to write claims. As you know, your proprietary rights are the claims, which might be one paragraph in a document of 100 pages of the patent document. And the one paragraph which defines what are your protection rights. For that reason, for provisional application, you need not have claims. You just disclose your invention, detailed scope of the invention, what you plan to do it, what you want to complain, what you want to protect or claim, and also including the work which you are still to do, but in that document. Then once a provisional application is filed, it is never published, is never a prior art. It remains on the record with the patent office, but it does have an application number. So that if somebody else does it later than that, you have a right on that. No, I am the first to file it, and here is the record. Then within 12 months, you have to submit a complete specification with the claims. If you do not meet 12 months period, then that gets abandoned and you lose all the rights on that invention. This is in all the member states of WTO. However, there is a difference in respect of patent term. In India, patent term is decided based on the date of provisional filing for 20 years. Not complete specification filing, for which there is a 12 months timeline. However, in USA, the patent term of 20 years is from the date of complete specification. So that if at all you go through provisional application process, then you get 1 year additional patent term. And as regards patent term, there has been a very, very rather important change in the US patent law. Because now every member state has to enact legislation in accordance with the TRIPS agreement. In US earlier, till 2013, the law was for pharma patents, 20 years from the date of filing or 15 years from the date of grant. Many times it takes a lot of time for getting a patent granted, maybe 6-7 years, many cases. If at all, patent is granted after 7 years, it had undergone prosecution. If it is from the 20 years from the date of filing, the actual protection, you get 13 years. However, the patent law said no, or 15 years from the date of grant, whichever is longer, you get 2 additional years. But now it has been in accordance with the TRIPS agreement normalized to have a uniform patent law in respect of the patent term all over the world. It is 20 years from the date of filing. This is another big change. In US, there was no provision for compulsory licensing earlier. However, now it has been enacted, but it is only for the export, not for the US market. If at all there is some drug which is not, then only Secretary Health can give the license. Only if at all it has to be made in US and exported to third world country where there is a shortage of drug, but not used in US at all. Similarly, European country also had to enact legislation for compulsory licensing. They decided among themselves that we will never ever provide a provision for compulsory licensing for a protected drug molecule to be made in Europe and to be used in European country, remember. It has to be made only if at all it has to be exported to third world country, not otherwise. These are the changes, but they had to enact legislation in accordance with Article 31 of this TRIPS agreement. So these are the matters related to compulsory licensing, which is a very, very important factor. Now we come to this registration design aspect of the patent law. What are the requirements for getting a design on any aspect? Like patent, design has to be new. there should not be any design which is already available for the same product. And designs are also provided in specific class. There are classes. You cannot have a one design for all the end users purposes. So that kind of limitation is there. Similarly, trademark also are like that. So I just wanted to touch upon the design aspect also. Now another aspect of this patent law is a opposition. As you know, patent once filed undergoes examination. Examiner searches the prior art to ensure the claims which are part of the patent do meet patent law in respect of section 2 or section 3D, section 3D, which is novelty and inventiveness. For that reason, they try to see what else is known in the public domain on that particular technology aspect. And a report is issued. Once a report is issued, then it has to be responded to within specific time, 6 months from the date of issue of the report. If it is not responded, patent gets abandoned. Or else, if you want a more time to respond, you have to submit an application with requisite fee asking for extension of the date for submitting response. And for that matter, also, if at all hearing is issued and one has to attend hearing, or else they want it to be deferred, they have to put a request in the requisite form with requisite fee for extension of the date for hearing. After going through all that process, a decision is taken whether to grant or reject a patent. If at all any competitor who are on the close watch what their competitors are doing in that specific technology domain, they feel that if this patent gets granted, it will be having a negative, it will rather impact their business adversely. There is a provision under law to submit on Form 7 pre-grant opposition while the patent is in prosecution. In that, they submit that there is enough prior art which makes this patent claims obvious, therefore should not be considered, and also say, please do call us for hearing in case you are not agreeing to our submission. So these are the very important factors. In US, there was no such provisions earlier. But now, during 2014, US, earlier, once a patent is granted, the matter cannot be taken with the US PTO, that US Patent Office. It had to be taken to the court of law. Only there a decision can be taken whether this patent should be revoked or not, and this was only after post-grant. At pre-grant, there is requirement. However, effective 2016, 13 September 2016, law has been enacted that pre-grant opposition can be submitted. Our inter-party review, IPR provision, one can rather request the patent office for IPR, inter-party review, for the specific patent claims, wherein the matter is discussed and the decision is taken whether patent should be granted or not. And like in all other countries, once the patent is granted, in India, the provision is to submit an application to the IPAB, Indian Patent Appellate Board. However, there is another provision within 1 year, within 12 months of the grant, once the patent is granted, the matter can be taken directly with the controller itself. telling on these issues, you should reconsider your decision and revoke the patent. After 12 months, controller loses the control over it, and the matter has to be taken up with IPAB, which is as good as High Court of India in respect of proceedings related to the patents. If at all applicant is not happy, IPAB also reject, then the matter is taken with the court, High Court, and High Court refers back. High Court does not have any right to say granted or not granted. They refer it back to the patent office based on their findings to reconsider. Whereas in US, once it is granted, then it has to be taken to the court of. There is a civil court, then federal court, then Supreme Court. And I would like to highlight one very important aspect related to the pharma sector in US. As you know, in US, any drug which has to be marketed has to undergo regulatory process. It has to get an approval from FDA before it can be marketed in US. For that, there are 4 provisions of the 4 provisions which are para 1, 2, 3, 4. Para 1 is when there is no patent for a drug. Para 2 is when there is a patent was there, but patent has expired. Para 3 is there is a patent, but they will market only after the patent expires, and this request is only for registration. And para 4 is there is a patent, because in US there is a document which is called Orange Book. Orange Book lists all the drug molecules which are approved by FDA, and it also rather lists patents related to the drug in respect of patent, related to the product and method of treatment and composition matters, not the process patents, only on these 3 aspects. If at all a party, a drug manufacturer, wants to market that drug in USA and says that the patent which are there in the Orange Book will either not be infringed, or they challenge the patent, the patents are wrong, and they can take up the matter to the court of law. They submit their application with the FDA under paragraph 4. That is the Hatch-Watchman rule, HW rule, Hatch-Watchman rule, which rather lists all these paragraphs I've been talking about. That case, within 30 days, applicant who submits an application under paragraph 4 to the FDA has to get in touch with the patent holder, original drug owner of that drug molecule, apprising them of the details for, based on which they have submitted application with the regulatory body. Then within 3 months, patent holder has to respond to FDA. If they do not do, then they rather have a right to, if they agree with whatever they have data they have submitted, to grant approval. If at all the patent holder has submitted a response to the FDA, then FDA cannot grant approval for 30 months timeline. Then within 30 months timeline, they have to discuss or take up the matter with the court of law parallelly, and take up the matter accordingly, and have to accept the court decision. This is another process in US, because US is the biggest pharma market, biggest, number 1 in the world. All the companies in India in particular also, like what Dr. Reddy, Sun Pharma, etc., the prime target is US market. And in US market also, when you submit an application for paragraph 4, it does protect patent holder for specific time. Then an application for para 4 also cannot be submitted for a particular time, and originator, owner of that patent must get some relief based as they have spent a lot of money in R&D to develop such a product. That is called NCE protection, New Chemical Entity Protection. That NC is provided for 5 years. In US, there has been a lot of argument with government of India also to have this respect to Indian law also, but it has not been, no decision has been taken as of today. That is called the data protection. In US, Red Book lists what is the NCE, New Chemical Entity Protection Date. Paragraph 4 says you can file an application under paragraph 4 365 days prior to expiry of NCE. Only 1 year in advance. And there's a big rush, big competition among parties to follow this, because anybody who files first, it is got first to file application to FDA for drug approval. If at all they're first to file 365 days prior to the NC expiry, if at all they get an approval, whether they prove it the patent is not right and patent gets revoked, or they prove the patent relates to the composition matter, they say they are not infringing their patent, they get full rights of 6 months. For those 6 months, no other competitor can market in US. That's a beauty, and that 6 months time may amount to billions of dollars worth business, depending upon the drug molecule. There has been a big fight, as you know, between Pfizer and Ranbaxy for that aspect, and that for Lipitor, a atorvastatin molecule for which reduces cholesterol. You know, that product in US itself was worth more than $20 billion. And Ranbaxy could get the patent revoked for specific polymorphic form, crystalline form of the molecule in US, but they did not. They were the first to file, and they had 6 months rights for that. That is how the laws have been enacted, taking into consideration national health services and also protection of the patent holders who spend a lot of money in R&D to get those patents, to get proprietary rights for outcome of their patent efforts. So, any question on any of these things? Any question? Now you please do let me know if you would like to have input on any specific, so that I can cover that instead of speaking in general. Please, let us make it interactive. Hello? Hello?
I think there are no questions in the chat box, so you can continue.
No, I have rather covered different aspects of the patent. I have covered the prosecution. I have covered this licensing. I have covered the pre-grant opposition. As regards pre-grant opposition, in Europe, there is a provision. In Europe, what they do is, it is a third-party observation. In India, a person who files a pre-grant opposition under Section 25, it is not imperative the person who files a pre-grant opposition has got a business interest. It's not imperative. For post-grant opposition, yes, only a party which feels are being impacted adversely can to file. However, in pre-grant, any third person can file it. But that third person becomes a party in deliberation during proceedings. That they have to, if they're called for hearing, they have to attend. Else, the patent holder gets an advantage. However, in Europe, there is a provision third-party observation, and that third-party observation is something that comes on the record and controller takes into cognizance while examining the patent application, and third-party observer is not part of the proceedings. He is never called. If he wishes, that's fine. But law does not makes it compulsory for the third-party observers to be part of the proceeding. That is how it differs from India in Europe. And in Europe, as I was just I just mentioned yesterday also, if patent application is filed, there's a provision that if at all your business interests are only in one jurisdiction or two jurisdictions, you need not go through the European Patent Office. You can go directly in those jurisdictions, and they're independent of each other. This patent will be examined and decision will be taken accordingly. However, if you go through European Patent Office, then European Patent Office examines your application, and their findings, if it is granted, becomes mandatory for all the European states to accept it. However, the patent has to be validated in each country to get protection, else no protection. And that timeline is within 3 months of the grant. As I had mentioned yesterday, PCT application, whatever patent you write WO, starting with symbol WO and the number, that is called PCT application. As I told you, it provides a window for 30 months timeline to file in other countries from the earliest date of filing. PCT application also undergoes examination and international search report is issued. That international search report which is issued gives an idea, gives a hint to the inventor what is the scope of his claim. If at all you do not agree with the report, there are two provisions. Under Article 19, you can amend the claim and submit to the WIPO, World Intellectual Property Office in Geneva, and that comes on the record, and those are the ones which are considered for evaluation by other member states. However, if you want to respond to the ISR, International Search Report, so that this examination, your claims, your application should be re-examined, then under Article 34, for which you have to pay a high fee, you have to submit response to the examination report of International Search Report, and that response of yours has to be re-examined by the examiner of your International Search Report to reconsider it in light with your response, and then reissue the report again by agreeing or disagreeing and amending his or her decision. This is the provision for PCT application. And PCT application is generally, as I told you, that ISR is certainly taken into cognizance while examination of such an application by other member states where it has been filed. And now one very interesting thing is happening. Once a patent application is filed in different jurisdictions, irrespective of, independent of each other, they undergo examination at individual places, at respective places. In India, there is a provision under Section 8. You have to inform and update the Indian Patent Office about the patent application filed in India, if at all it has been filed in any other places, and current status of their patent application in other jurisdictions. If it is not complied with, is the revocation of Section 8, and it can be challenged. If at all granted, it can impact adversely to the patent holder. Recently, there has been a move among the big member states like US, Japan, Europe, Korea, Taiwan, etc., to evolve a process on this line, which is called Patent Prosecution Highway, PPH, wherein if at all application is filed in 3-4 in different cases. Under PPH, they share their findings among each other so that there's a uniformity of decision among member states on the specific patent. There is no difference of opinion as the patent law is primarily based on the TRIPS agreement, which provides protection on similar lines. During search while examination, is likely that somebody may miss some prior art which is relevant, and at some other place they get it. So by sharing such outputs, findings of each other among each other makes the decision uniform and also fast. Otherwise, it may remain in cold storage at one place for a long time. But PPH system is such which makes it faster and efficient. With that, I think I would like to bring an end to my talk, as it has covered most of the aspects. But if at all you feel there is anything else you would like to know, you're welcome. I can touch upon that. Because this is a topic for which one can speak unabated for hours and hours together. But it has to be what is of interest to the audience.
Sir, we have a question in the chat box by Darvi Sagar. If the copyright owner dies, can any member of the family claim it?
No, because original owner, whosoever it is, he assigns the rights to an individual whom he wants. If he wants to assign the rights to all, it is their wish. The discretion is at the original copyright owner. If he says no, it has to be assigned to one individual, then only one. It's at the discretion of the copyright owner. It by default, it doesn't come to all. But if at all it is a law, if at all there is no will or there is no assignment, then it has to be for the court of law, and then it becomes rather ownership to all the members of the family. It as per the standard law of inheritance. Does it answer?
So I hope it answers the question, Darvi Sagar. And if anyone in the audience has any question, please feel free to ask question.
So you're welcome to ask any question. So we can certainly deliberate on that and try to clarify on that specific aspect. So this indicate either whatever has been deliberated has been understood or nothing has been understood.
So if no one has a question, we will end the session by summarizing. Is it okay?
Yeah, that's fine. That's fine with me. And I hope since this has come abruptly to me, so instantly I had to decide to cover all aspects in brief.
Yes, sir. So thank you so much, Dr. Charanjit Sehgal, sir, for your valuable inputs and sharing your immense knowledge with us today. To summarize in the session, you gave us the insights on provision of patents in different countries and also said about the court hearing perspectives of USA and its case study. You talked about the amendments of patent law and also gave a brief explanation of Indian patent law and various sections associated to it. You further talked about the designing aspects of patent law and the procedure to file a patent in India and also USA. You also explained various terms associated to patents and the laws one must know before filing a patent. So, with that, I would like to thank you for your valuable time and will end this session.
Thank you very much indeed.